More of that. So, ladies and gentlemen, I'd like now to begin with our Law Day luncheon presentation. It's my pleasure to be able to introduce today's luncheon program. As we celebrate Law Day and honor our system of justice, it is timely and appropriate to pause and reflect on the foundation of the rule of law in our state, which is, of course, the Alaska Constitution. Over 50 years ago, our Constitution's framers gathered here in Fairbanks in the dead of winter to craft what they hoped would be an enlightened and enduring document to guide Alaska's future. Of perhaps the greatest significance to those of us in the legal profession are the provisions of the Judiciary Article, which govern the structure and functioning of our court system, including our method of selecting judges. For over 50 years, Alaska has employed a merit-based system which seeks to ensure that only the most highly qualified members of the bar attain the bench, the tallest timber, in the words of one Constitutional Convention delegate. As you may know, there is a resolution currently pending in the legislature to amend the Constitution and change our judicial selection process in a manner that threatens merit selection. The effort is controversial and officially opposed by the Alaska Bar Association and the Alaska court system. Our speakers today will explore the rationale behind the Judiciary Article and examine the many concerns that current efforts to amend it raise. We are very fortunate today to have someone with us who can speak directly to what Constitutional Convention delegates were thinking, because he was one of them. Vic Fisher has spent the past 60 years explaining and defending our Constitution, and we are honored and delighted to have him with us today. He will be introduced after a brief presentation by our other guest speaker, retired Justice Walter "Bud" Carpeneti. For most of us, Justice Carpeneti needs no introduction. He is one of the most long-standing jurists in our state's history, devoting 32 years of his career to Alaska's judiciary. He was appointed in 1981 as a Superior Court judge in Juneau, and in 1997 to the Alaska Supreme Court, where he served until his retirement in 2013. During his tenure in our state's highest court, his colleagues elected him Chief Justice for the 2009 to 2012 term. As Chief Justice, he promoted civic education, public understanding of our justice system, and founded the Supreme Court Live program that has brought oral arguments to high schools across the state. He has served as the founding Alaska chair of the iCivics program, which was initiated by retired U.S. Supreme Court Justice Sandra Day O'Connor. Justice Carpeneti earned his undergraduate degree in history from Stanford University. He has a law degree from UC Berkeley. He came to Alaska in 1970 directly from law school and clerked for the late Justices John Diamond in Juneau and one of our most legendary characters here in Fairbanks, Jay Rabinowitz of Fairbanks. He has made his home in Alaska for over 40 years. He and his wife, Ann, raised 4 children here. And today, all of their children either live in Alaska or maintain strong ties to this state. 3 of his 4 children are lawyers, and the 4th is a legislative aide. Devotion to the law and to Alaska clearly runs in the blood of this family. Throughout his career, Justice Carpeneti has been a staunch advocate for the merit selection of judges. When current efforts to amend the Judiciary Article gained momentum in the legislature last year, he knew he had to do something. So barely a year into retirement, he interrupted his plans for a leisurely schedule to co-found Justice Not Politics Alaska, a nonprofit organization devoted to preserving the Judiciary Article and protecting our current system of judicial selection from increased political influence. Today he serves as the organization's co-chair and has spent much of the past year educating legislatures and members of the public about the importance of fair and impartial courts. We are fortunate to have him here today to speak to us I hope you'll join me in welcoming Bud Carpenetti.
Thank you, Jeff. It's not often that I come to a microphone and have to adjust it down for my height. Those remarks were very kind and probably a little over the top. I didn't do too much interrupting of my leisure time, and I've used it well. Thank you for being here today. This should be an amazing program. I hope that it is, with Vic Fisher, one of only 3 surviving delegates to Alaska's Constitutional Convention, here to talk about one of the crown jewels of our Constitution, the Judiciary Article, Article 4. Before he joins us, however, you might be asking yourself why the subhead above Alaska's merit selection system in the crosshairs. And the answer is easy. Senate Joint Resolution 3, a proposed constitutional amendment introduced by Senator Pete Kelly of Fairbanks, which in my view would gravely threaten the fairness, the independence, and the excellence of our courts, and open our state to at least the possibility of the kinds of abuses never seen here before, but unfortunately all too common in the other states. And to show you why I entertain that belief, I'd like to start with the theme of this year's convention, celebrating the Magna Carta and 800 years of the ongoing struggle to honor the notion of self-government in a nation of laws, not of men. It was, of course, a really revolutionary concept, challenging the divine right of the monarch in many ways. And as the Globe and Mail said recently, it's been called democracy's birth certificate and remains a powerful symbol of justice triumphing over tyranny, especially in our time when the concepts of freedom and fairness are in constant flux. And I thought that important because that quote comes from a couple of months ago, not 800 years ago. And it shows that the struggle continues to this day. And while kings are of no continuing concern in this country, the imbalance of power brought by either or threatened by either the executive or the legislature poses a threat to the one branch of government meant to impose limits on government and to protect individual rights, the judiciary. Returning to the days when kings were players in the affairs of this country, our Declaration of Independence had this to say about George III. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. So even at the founding of our country, this concern about judicial independence was strong. And so our constitutional framers took great care to create a judiciary that was independent, specifying that judges could not be removed except for cause and their salaries not diminished while they were in office. And while the ratification of the Constitution itself was being debated, the Federalist and Alexander Hamilton in the Federalist number 78 made clear the central importance to the new government of judicial independence. Now, in this quote, it's clear that he's talking about independence from encroachment by the legislature, but the point remains the same. While Alaska's framers took a different approach than lifetime appointment to ensure independence, they too nonetheless valued as highly as the federal framers the notion that the judiciary must be independent and beholden only to the law and not to the will of the executive or the legislature or even the public in a given case. The court in Marbury versus Madison in 1803, we've already heard today from Professor Chemerinsky, then established the doctrine of judicial review of the acts of the coordinate branches to determine whether they complied with the Constitution, thus establishing both the doctrine of judicial review and cementing the doctrine of separate and co-equal branches of the government. And so we have the really important concept of judicial independence. And I looked up the Constitution Project. It's a bipartisan group, and I really mean bipartisan. It's the folks that sit on its board come from all ends of the political spectrum. And they set this out, and I think it's an important principle for us to start off with. Judicial independence is the principle that judges should reach legal decisions free from outside pressures, political, financial, media-related, or popular. Judicial independence means judges must be free to act solely according to the law and their good faith interpretation of it, no matter how unpopular their decisions might be. It means judges need not fear reprisals for interpreting and applying the law to the best of their abilities. An independent judiciary is a cornerstone not only of our justice system, but of our entire constitutional system of government. Only a truly independent judiciary, free of pressure from and indebtedness to political parties, public officials, interest groups, and popular whim, can be truly accountable to the public it serves. And there's really two kinds of independence, and I think both are important. First, decisional, as to the individual judge in the individual case, and institutional, as to the judiciary itself and its role as a fully co-equal branch of government, separate from the legislative and the executive branches. As Sandra Day O'Connor has said, the founders realized there has to be some place where being right is more important than being popular or powerful, and where fairness trumps strength. And in our country, that place is supposed to be the courtroom. So, how did we arrive at the mid-20th century at the grail of merit selection? I'd like to take 2 minutes to go through a real quick history of this subject. In broad terms, the 18th century was the heyday of lifetime appointment. The 19th century witnessed a populist reaction that led to elected judiciaries. And the 20th century, in a reaction against the excesses of big politics and judicial selection, trended toward merit selection, utilizing independent nominating committees charged with presenting lists of highly qualified applicants to the governor for appointment, with retention election to follow. That brings us to 1955 and the Alaska Constitutional Convention, convened almost 60 years ago right in this city. The 55 delegates represented a cross-section of the territory of Alaska with a diverse assortment of occupations represented by the delegates. I had fun putting this together, counting up who did what. It's not true that lawyers dominated the convention. We've heard that in some of the arguments. There were 13 lawyers, there were 55 delegates. There were folks from all over the state, and they represented all kinds of occupations: miners and mining engineers, fishermen, self-described housewives, pilots, clergy, engineer, farmer, builder, photographer, teacher, et cetera, et cetera. It was a great cross-section of Alaska of 1955. The delegates had a good sense of the challenges before them, and they made great preparation to complete their tasks. Tom Stewart, who would become the secretary to the Constitutional Convention, as a member of the Territorial House, contacted various experts in state administration and contracted with the Public Administration Service to prepare studies on each of several subject areas that the Constitution would have to address. The Judiciary Committee was well organized and efficient. Following its debates and discussions, which I hope we will hear a lot about today from Vic Fisher, it adopted the Judiciary Article, which was ultimately accepted almost unanimously by the Constitutional Convention. The high points of the merit selection were nomination by the Judicial Council, which was charged with finding the best available candidates, the best available timber, or the tallest timber, as one of the delegates said, and sending on at least 2 names to the governor. The council was to be composed of 3 lawyers appointed by the Board of Governors of the Bar Association, although historically the Board of Governors has held an election in the judicial district involved and has, I believe, always appointed the attorney prevailing in that election, but it's technically appointment by the Board of Governors. And then 3 laypersons appointed by the governor and confirmed by the legislature, and then finally the Chief Justice, ex officio, who votes only when his or her vote would affect the outcome. Essentially, the Chief Justice votes to break ties, or if you have a 3-2 vote because somebody's missing and there's 3 votes in favor of sending the person on, 4 are needed, then the chief votes in that instance. Sorry, I'm 1 slide late. This is what should have been up on the screen as I was just describing that. I'm really new at this. Actually, I think I'm doing really well so far, so. This proposal, this outcome, was regarded as the best compromise between competing values in judicial selection. As George McLaughlin, who was chair of the Judiciary Committee, said, the best compromise and the best solution to a vexing problem between those who feel we should have lifetime tenure so judges can be absolutely independent, and those who feel we should have short terms so that judges could be subject to the popular will. And of course, judges are subject to the popular will now in terms of the retention elections, which they stand for every 4, 6, 8, or 10 years, depending on which court they occupy. As Jay Rabinowitz said, our state judicial system really changed in 1955 through the wisdom of the delegates to the Constitutional Convention. They rejected the concept of straight partisan election of judges, and they rejected the federal appointment scheme, which is executive appointment, confirmation by the legislature, and lifetime tenure on good behavior. So they came up at that time with the Missouri Plan, which is merit selection, merit retention. This is probably one of the greatest things that the Constitutional Convention did because, in my view, the Judiciary Article is a splendid example of foresight and incredibly skillful drafting. Now there are about 35 states that have some form of our system, and there isn't a single state that wouldn't want our system in full. So, nirvana, we reached it. It took 200 years plus after, it took a long time. Took 6 centuries after Magna Carta, and a long time even after the federal Constitution, but at least by statehood for Alaska, we had got it right. A system that looked for merit at the initial phase, and then gave electoral politics its due in the appointment itself. The governor, after all, is the winner of the last election and makes the final choice, and turned it all over to the people at a retention election 3+ years after appointment and periodically thereafter. So, end of the story. Can we all go home and do something else? Well, not quite. And the reason for that, and the reason for the existence of Justice Not Politics Alaska, is Senate Joint Resolution 3. In a nutshell, I'm not sure how readable that is, it doubles the number of gubernatorial appointments to the Judicial Council, and it requires the attorneys elected by the bar to be confirmed by the legislature. Now, given a merit selection system that has produced a judiciary free of the taint of corruption for about 6 decades, free of the corrupting influences of partisan elections, and this is my personal and probably biased view, but produced a judiciary that has performed excellently over the past 56 years of statehood, it's not only fair, but I think incumbent to ask, why change this system? I've tried to listen carefully to the arguments of the folks that, have I gone the wrong way there? Yeah. I've tried to listen carefully to the arguments of the folks that have proposed SJR 3, and I've heard 5 rationales. And I will say, I think they have shifted quite a bit over the last 2 years, but there are at least 5 identifiable reasons that are given. Not one of them holds water, and I'd like to go over each briefly in this presentation. The first argument is that, well, Alaska's an outlier in the prominent role attorneys play on the Judicial Council, and somehow we should get in step with the rest of the country. You know, in answering the outlier argument, I'm really tempted to say, and I'm tempted to say this because it's true and because it's enough of a response, I'm tempted to say that, as the bumper sticker says, we really don't give a damn how they do it outside. And I say that because we should stick with merit selection because it's the best system, even if no one else used it. But I think it's important also to say that we're not such an outlier. In 1955, it was already in use. As George McLaughlin said, in discussing the Missouri Plan that was in effect, the whole theory of it is that a select, and I'm going to ask you in advance to disregard the gender indications in this quote because they can be off-putting, but this was almost 60 years ago. The whole theory of the Missouri Plan is that a select and professional group licensed by the state can best determine the qualifications of their brothers. It is unquestionably true that in every trade and every profession, the men who know their brother careerists the best are the men engaged in the same type of occupation. The theory was that the Bar Association would attempt to select the best men possible for the bench because they had to work under them. So the idea was current then, it was thought about, the reason was given. But beyond that, several states have moved in whole or in part toward merit selection over the last 40 or so years, and this is a rough approximation of those states. This is a statement of those states that have adopted some or all of the aspects of the merit selection system. And so I think it's just inaccurate to say that we're this terrible outlier. There was a slide that somehow I just passed over that I wanted to conclude that first discussion with, and it was from the American Judicature Society, and it says quite simply, merit selection is the best way to select the best judges. So in terms of the outlier argument, I don't think it holds water. The second argument that was advanced by the backers of SJR 3 is that lawyers who make up 4 of the 7 members of the council, quote, dominate the non-lawyer members. There are simply no facts to support this argument. The idea is there's the 3 lawyers that the Board of Governors appoints, and then there's the chief, so you have 4 lawyers. Well, let's look at the facts. Most of the council's votes are unanimous or nearly so. 81%, 932 out of 1,149 votes taken in the last 30 years are either 6-0 or 5-1. And so the idea that any one group has dominant sway over the council seems misleading to me. And I guess I should, and I didn't put it down, but I probably should have started with the argument that people like Vicky Tina Williams, Bill Gordon, Eleanor Andrews, are going to be overwhelmed by somebody because that person has a J.D. after their name is ridiculous on its face. And it's insulting to those people. And so that's, I guess, the first argument, that historically there have been councils that have had very, very strong public members or non-attorney members, and the idea that because there's 3 lawyers and the Chief Justice are going to be overwhelmed is ridiculous. But when you look at the numbers, the actual votes, most of the votes are unanimous or near so. Ties of any kind, and when I say any kind, I mean any 3 members on one side, mixture of lawyers and non-lawyers, and any 3 on the other side, a mixture of non-lawyers and lawyers, are very rare, 6% of the time. Ties in which you have what I think of in my mind as a perfect split or an even split, 3 lawyers on one side and 3 non-lawyers on the other side, are even more rare. They are extremely rare, about 1.4% of the time, or 16 out of over 1,100 votes since 1984, when they started keeping records that are detailed enough to draw these conclusions. And then going on, in council tie votes, the only time that the Chief Justice votes, and the only time that this theory about 4 versus 3, 4 lawyers and 3 non-lawyers, can even come into effect, the Chief Justice usually votes to forward the nominee's name to the governor, in fact, about 3/4 of the time. So, the idea that somehow there's a cabal of lawyers that is keeping qualified people from going to the governor just doesn't add up when you look at the actual numbers. And then finally, out of those 16 perfect 3 lawyers on one side, 3 non-lawyers on the other side ties, in about half of them, the Chief Justice voted to send the nominee's name to the governor. So it seems to me that the huge weight of opinion over the last 30 years, not opinion, of fact over the last 30 years, shoots that argument out of the water. Now recently, because the historical facts don't support their claims, supporters of SJR 3 have phoned their argument to state that, well, in recent years, the Chief Justices have been faced with attorney versus non-attorney split votes and have sided with the attorneys, thus dominating the non-lawyers and keeping good people from going on. And again, I think the facts simply do not support that claim. Since 2010, the Judicial Council has voted 212 times for 25 judicial vacancies. The Chief Justice voted 10 times, which is right within the historical averages during that time. In fact, it's a little bit less, because historically the CJ is called upon to vote, remember, in about 6% of the cases. In the last 5 years, it's happened in 5% of the cases. So I think this argument simply doesn't hold up. The third argument that's made is that if we increase the number of gubernatorial appointees to the council, we would attack the problem of diversity in the judiciary. We would attack the problem of a too narrowly focused council. Well, the first argument in response to that is SJR 3 does not require demographic, geographical, or ideological diversity in the governor's appointments. The council doesn't say anything about that. And in fact, the Constitution already says that the governor is supposed to make his or her appointments with due regard to area representation. So the current Constitution covers that subject. The proposed change doesn't cover it. Secondly, past governors have appointed minority members and rural members frequently, but no such appointments have been made for over a decade. So I don't think the problem is in the system. The third argument is giving one person, the governor, the power to name 2/3 of the council would undermine the diversity of ideological views and perspectives. It simply puts too much power in the hands of one person. And finally, to the extent that the argument is made that there needs to be more diversity on the council, it's, to me, compelling that the interest groups or the groups in this state that would supposedly be the beneficiaries of that have unanimously, as far as I can tell, come out against it. AFN in its last convention unanimously voted against SJR 3. The ANCSA Corporation CEOs have sent a letter in which it states that all of them oppose SJR 3. The Tanana Chiefs Conference has weighed in as well. And so it just doesn't seem to me that any of those arguments hold up. And finally, if we've got this right, if you remember that slide a little bit back, the claim was, well, it's just more democratic to have a broader input into the selection of judges. And I just don't think these claims are substantiated. The current system has a popularly elected chief executive make the appointment, followed by a retention election 3+ years after the appointment. Our judges in Alaska are subject to the popular will like no other. I mean, I think we take second place to no one in the argument as to whether or not the Alaska electorate has a chance to be heard on who should be their judges and is better informed, or has the possibility of being better informed through the work that the Judicial Council does and puts on their website about the votes that they are about to cast than anyone in the world, or as well informed, I think better informed than anyone else in the world. So I don't think that argument has a lot of traction to begin with. But continuing on and taking on the question of legislative confirmation, as George McLaughlin, again, the chair of the Committee on the Judiciary, said when this issue came up, and it was pretty hotly debated, he said, if you require a confirmation of your attorney members by the legislature, you can promptly see what will happen. No longer is the question based solely on the qualification of the candidate for the bench. If political correctness enters into the determination of the selection of those professional members who are to be placed upon the Judicial Council, the whole system goes out the window. All you have is one other political method of selection by your judges. And I think that's right. I guess the really interesting thing about that quote to me was that the term political correctness was in use in 1955. I thought that was kind of a recent thing. Who knew? But I think the point is well stated, that the downside here is very high. As Tom Stewart said, Alaska is fortunate to have the constitutional guarantee, the merit system for the selection of judges. Our merit system has worked well in Alaska. It has produced high-quality judges with integrity and abundant skills, and it has kept out corrupting political influences that trouble the other states. And finally, as Fairbanks' own Frank Barr, I thought it would be nice to end with a local representative. As he said, I believe that this committee report that outlined the system of selection of our judges is just about as perfect as can be. It's not perfect, nothing's perfect, but I think it is a system we want. So with that backdrop as to the issue that we're going to be talking about today, I'd now like to introduce my co-presenter for today's program, someone who literally wrote the book, and there it is, Vic Fisher. Vic grew up and attended school in Berlin, Moscow, and New York. He served in the U.S. Army during World War II in France, Germany, and the Philippines. In 1950, he moved to Alaska, where he worked in community planning and owned a small cabin on F Street when the Anchorage Bowl looked like, sorry, that was the military picture. When the Anchorage Bowl looked like this, that's the cabin that Vic lived in. During the push for Alaska statehood, he was elected as an Anchorage delegate to the Alaska Constitutional Convention, which took place at the University of Alaska Fairbanks from November 1955 to February 1956. He was among the youngest delegates and is seen here speaking during the convention debates. That's Vic over way to the left of that. And another picture of him that's a little bit better, speaking during the debates. On February 6, 1956, he was one of the 54 delegates from across the state to sign the final convention document. I have to say that I ran this introduction past Vic, and it originally said 55, and he said, well, only 54 of us, and I knew this, I'd forgotten it, only 54 of us signed it that day. One of the delegates from Juneau didn't sign it until a substantial period of time later. So he was one of the 54 on that day, although they all eventually signed it, which was approved by Alaskan voters later that year by a margin of 2-1. In the many years since, Vic Fisher has been a dedicated public servant, serving in the Alaska legislature and as founding director of the University of Alaska's Institute of Social and Economic Research. He has worked tirelessly to support and defend our Constitution and to explain to Alaskans the goals and the objectives of our state's founders. He has chronicled his amazing life in the recent memoir, To Russia with Love. In 2002, Vic spoke with other surviving delegates to our Constitutional Convention at a bar historians luncheon to commemorate our founding document. You will notice on the far right of this photo another convention delegate who also played a key role in our state's founding and who we had hoped would be here today, and that's Jack Coghill, but unfortunately he's not able to be here. He was another young delegate to the Constitutional Convention who has devoted much of his life to public service, and his legacy continues today through the service of his son, Senator John Coghill, who currently serves in the legislature and who, again, we also thought would be here, but apparently his duties have kept him in Juneau this week. To our knowledge, Vic Fisher, Jack Coghill, and retired Superior Court Judge Seaborn Buckaloo, pictured here at the 2005 Bar Historians Luncheon, are the only surviving delegates of our Constitutional Convention. We are so grateful for their legacy, and we live with the benefit of their vision every day. And now I would like to invite my co-presenter to the stage. Please join me in welcoming Vic Fisher.
Thank you.
Well, you can't imagine the stress of A, having to appear on a stage with Vic Fisher, and B, having to manipulate a PowerPoint. So 1 out of 2 so far. Is this mic on? Yeah. Is the mic on? Okay, thank you. I relaxed too soon over the technical issues. Vic, I'd like to, first of all, thank you for agreeing to do this. It's an incredible thrill and honor and privilege, I think, for all of us to be able to put some questions to you and to hear the inside story of the Constitutional Convention and just to be with you today.
Thank you, Bud. I'm delighted to be here. I see a lot of friends. I see a lot of people I've admired for many, many decades, and it's a real honor and real pleasure to be here, especially sharing this table with Bud Carpeneti.
Well, thank you very much. Let me start the questioning period by trying to go to the pre-convention era. I don't mean necessarily decades, but before the convention. Let me ask some basic. How old were you? You were one of the younger ones, but how old were you?
I was 31. Jack Coghill was 30. Tommy Harris from Valdez was 29. So I was the third youngest.
Wow. And at that time, what were you doing in terms of an occupation?
I was unemployed. No, I had been planning director for the city of Anchorage, and just about this time, 60 years ago, I resigned that position, so I was completely free to run for the Constitutional Convention.
And your background was you'd grown up in these exotic places, but come to this country as a younger person, then gone to school here, and you were out of the Army, obviously. And what were the circumstances of coming to Alaska?
Oh, it was just a dream when I was going overseas on an Army transport across the Atlantic Ocean. I was thinking about where I want to alight after the war, assuming I came out of it. And I started reading books of the States, and further west I got, the more I liked going west. And having been 10 of my first 15 years in Russia, where my father was an American correspondent, I was interested in North, and there was Alaska. And so when I got out of the Army, I wrote to the University of Alaska, asked if they had a course in architecture, which I saw as a foundation for city planning, which was a profession I wanted to pursue. But they had mining and English and agriculture and stuff like that. So I went back to Wisconsin, finished Wisconsin, and went on to graduate school, got a planning degree, and lo and behold, the first professional planning job opened up, and it was in Alaska that I grabbed, and here I am.
Okay, so you're 31 years old, you're a young planner, and the Constitutional Convention is put on the docket. What made you decide to run for delegate?
I was one of a lot of young veterans and some older people, but mostly young, who were active in a group called Operation Statehood, and it was a citizen group to help promote statehood. And we had lots of activities. Barry White was the president of Operation Statehood. I was the vice president, and it was a matter of working for our civil rights, because we could not vote for president, we could not vote for U.S. senator. We were completely dominated by bureaucrats from Washington, D.C., and people who would talk about federal overreach should have lived in Alaska during territorial days.
So I wanted to ask you about the atmosphere regarding the possibility of statehood, and you've obviously started to talk about that. What was it like? What did it feel like being in Alaska then?
Most Alaskans were for statehood. It was a strong movement. It was totally bipartisan, and it was just sort of a universal drive. But each year, each Congress, it seemed that just as things started to happen, just as one committee approved statehood in the House, the Rules Committee of the House killed it. The Senate might move, and it was killed. And each time, it was very frustrating. And in 1954, Congress adjourned and still hadn't done anything about statehood, even though it seemed closer than ever. And that's when the decision was made, let's write a constitution. We were running parallel with Hawaii, which wanted statehood. They already had a constitution. We wanted to prove that we're mature enough to become a state. We knew what we were about, and we will prove that we can write the best constitution in the United States.
Let me ask you, when when you were thinking about writing a constitution and saying we could write the best constitution in the United States, was there any particular thought at that time as to the kind of judiciary that you wanted, or was it more generalized towards the idea of we can prove that we can govern ourselves?
Well, yeah, I would say the basic idea was we can, we'll demonstrate. It's just that the Constitutional Convention, writing Constitution, was an active step toward statehood. And those of us who were sort of on the active front lines saw the Constitution as a step toward statehood. It was really after we came to Fairbanks, after we arrived here, and the reality sank in that we are writing a constitution for the future state of Alaska, that we really got down to that became the overriding purpose, that statehood was always in the background, but it was really looking to do the best possible job for future generations of Alaskans. Judiciary was one of the fundamental parts of a constitution. There was very strong belief that the three branches of government should be effective. This was very important because we had been a colony of the United States. We had no say in the judiciary. We had a territorial legislature that was totally ineffective. We had a governor appointed by the President of the United States. We wanted to have a system that was strong, where a responsibility was fixed, and each branch was effective and independent. And when it came to the judiciary, it was to be parallel with a strong executive branch headed by a single elected chief executive, to have a legislature that was effective and streamlined, and to have an independent judiciary, one that was independent of the executive branch and independent of the legislature. And I think that is essentially what we tried. And obviously, the judiciary has, over the decades since statehood, performed more effectively than the legislature and the executive put together.
I did not know that Vic Fisher was going to say that. I just wanted let me ask you, in terms of the considerations that you dealt with in structuring the judiciary. First, did the territorial experience with the federal courts under the territory of Alaska shape the views of the delegates in terms of putting together a judiciary system?
Certainly, we were all familiar with the federal system, which is essentially was run from Washington, D.C., and we want to have our own system. But also, we saw that lifetime appointment was not something that any one of us contemplated. Mm-hmm. I mean, we had seen it, for better or for worse, it's part of the federal system. But one of the things that we did in the Judicial Committee, in all of the committees working on the different parts of the Constitution, was to see what other states had done, what their experience was. More than anything, we learned what not to do. Occasionally there were examples that were moving in a direction that was closer to what modern thinking was, where the leaders in whatever subject matter was under consideration, what the constructive contemporary thinking was about what should be, might be considered by the Constitutional Convention. And so the Judiciary Article was very much like other articles. It fell into place in some ways far easier than a local government structure where we could learn nothing from other states except what we should not do. Resources was very difficult to put together because we dealt with the full gamut of resources rather than just grazing or water rights or mining. And
Let me
stop.
Let me follow up on, you said appointment for life was something that had no currency. What about other models, full partisan elections? Was that discussed in the debates?
The only alternative to what we have in the Constitution today that was considered by the Convention was a straightforward partisan election system. And that came up on the floor of the Convention. I don't think the Judiciary Committee seriously discussed that or considered. They may have discussed it, but they did. I don't think they seriously considered it. But it was brought up by Fairbanks Delegate Robert McNeely, an attorney, who argued vehemently that to have a democratically elected judiciary, judges and justices, would protect us from political influence and corruption. And we had serious discussion. That was voted, the first time it came up was voted down by, I think, something like 52 in favor of the merit system that was proposed by the committee, with only 2 votes for the election process. It came, this was in second reading, and in third reading, the final adoption of the article. Bob McNeely brought it up again. We had another discussion, another round, and again overwhelmingly defeated the idea of elected judges. And so there was never any question about the makeup of the Judicial Council or any question about the concept of the Judicial Council.
Let me interrupt you there and ask you a kind of a pointed question about the debate that's going on now, which is that the bar, which has been sometimes referred to as an elite guild, has way too much say in the appointment of judges under the system, and that's why the governor should be given twice as many appointments. And I guess the general question is, why the role for the Bar Association that the framers chose, to equal with the governor's appointing of 3 members?
As I mentioned, the idea was that we want an independent judiciary. We want the best qualified people to rise up to judgeships and justices. And one way of getting there was to get the people who have to work in the judicial sphere, who best would know the candidates or applicants for judgeships, and have to work with them, have those people be part of the process. Well, the idea was if we let the governor decide which lawyers should be on the Judicial Council, you right off the bat have you have politics coming into it. The Bar Association, the organized bar of the state, was the vehicle to get the appointments of the best qualified attorney members for the counsel. So again, there was no dispute about that. That having the Bar Association be the vehicle.
What about the Chief Justice's role, the tie-breaking role, which, as we've seen in these votes, happens pretty infrequently? What was the thinking behind creating the chief?
Let me ask you. I looked at the Constitution. It doesn't say that the Chief Justice votes only in case of tie.
That's
that
true.
must be by rule of the courts. So far as I'm concerned, Chief Justice is free under the Constitution, is free to vote in all cases.
Oh my gosh.
So there was no there was no feeling that having 4 attorneys would overwhelm the non-attorney members. That's sort of the attack on Chief Justice being biased or something is just ridiculous.
So I take it that you'd have a similar answer to the notion that it's a conflict of interest for the Chief Justice to vote on in tie situations where the Supreme Court is at stake.
Well, I have seen the Chief Justices since the, you might say, beginning of time. But I think we have had most phenomenal Chief Justices, and the Chief Justice is the chief administrator of the court system. That Chief Justice has probably more of a vested interest in finding the best people to be judges than anybody else in the state. So I would say, right on, get the Chief Justice right out front on that. But I'm sorry if I'm treading on dangerous territory here.
No. The only thing dangerous about this interview is asking a question and looking really foolish when Vic Fisher says, that's not what we said. We'll come back to that later. And I see that we're close to running out of time, but I did want to ask this question. In your book, Alaska's Constitutional Convention, you quoted consultants to the convention who were somewhat critical of the Judiciary Article, and some of the folks supporting SJR 3 have seized on this quote, which basically says Article 4 goes a long way towards withdrawing the Judicial Council from popular control and turning it over to the Bar Association. And you also note that that criticism at the time didn't carry much weight with the framers, that it didn't even make it to the floor, and that the Judiciary Article was approved practically unanimously. But I'd like to know, what was your reaction to that criticism in 1955, and how do you feel about it now?
Well, I was very close to the consultants because I'd worked in the municipal arena before the convention and worked with them nationally. And so they brought that criticism to me, and I told them, the convention has already overwhelmingly decided this is the way to keep the judiciary system away from politics, away from control by the executive or the legislative branches, and that this was already a compromise, and that the retention elections provided the democratic controls necessary. And I think the retention system has worked extremely well because it's not just the lawyers and lay people on the Judicial Council who are involved in recommending retention or not. There's a whole process of law enforcement people, jurors, and others being queried about judges who are up for retention. So we have a broad system in place that wasn't anticipated then. But anyway, Bill Egan, who was not an attorney, told the consultants they can put a memo together, but the committee of chairmen, we had 18 committee chairmen of, or 15, only about one-third of them were lawyers, and they rejected doing anything about the criticism. It's totally irrelevant. We have a good democratic underpinning for the judicial system through the process that we have.
Okay, thanks. Let me, boy, time flies when you're having fun. I'm going to wrap this up. I'm going to skip over a lot of things that I'd hoped to ask you because we wanted to leave a minute or two for questions from the floor. But ask you this wrap-up question with the perspective of 60 years of experience for Alaska's grand experiment. How do you rate the performance of Article 4? Is there something you do differently, or are you happy with it?
Yeah, I'm totally happy. As I was chatting with Bob Coates, the one criticism I have is the age 70 retirement requirement. And I want you to know that that seemed very reasonable when I was 31 years of age.
Well, let me thank you for coming here today and sharing your wisdom with us. I'm looking for Jeff. Can we open it for a few minutes questions, or? Okay. If there are questions of Vic as to, yes, Mike Wolverton?
You know, I have more of a question for the group of judges who are sitting or retired judges here. I wonder how many are like me. I would never have ever run in a political system for a judgeship, not in a million years I'd be driving a truck to the place, all right? I wonder how many people in this group are in that group who would never.
Thank you. Any other tough questions for Vic?
Well, but let me put it to you. You have been Chief Justice and had a whole career in our judicial system. I think your bias has come through, but would you do a wrap-up of, have you seen any politics getting into the selection of judges? Have you seen any corruptive influences, or to what extent have there been problems with the system that call for any kind of changes in the article?
Well, I'd have to say that I think the system really demands a lot of the people that are in it, and I think it brings out the best of the people that are in it. And I mean that in the sense that you don't decide to try to become a judge unless you're willing to just kind of put your life on hold for 6 or 8 months, expose yourself in a lot of ways to everything. It's a tough process, the bar poll, but you have the sense that you're getting a fair hearing from people that really want to make sure that the bench is a good bench, and that's the merit phase. And then you have the political phase, which is perfectly appropriate in that the governor, who's the elected representative of the people, makes the final choice. And then the vote, you know, like every other judge, when the retention election's coming up, I'm kind of thinking, oh, what have I done wrong? Or, you know, how are the voters going to see this case or that case? But it demands of the people that do it that they be willing to kind of make an open book. And then once you're in the system, you have the freedom and the luxury and the responsibility of making the best decision that you can make on that case according to what the law requires. And that is, you know, I don't think I had a day in my life as a judge that I didn't make some decision that if I hadn't been in another kind of system, I would have done it differently. I mean, judges all the time are applying laws that they would not have written that way, or that maybe are a little too tough in one regard, or they're too lenient in another regard, but you have the luxury of knowing that you take that out of it. What you do is try to figure out what the legislature was saying, or what the constitutional framers meant, get the facts straight, apply the facts of the law, and then you go on. And so it's a big responsibility, but I really agree with Jay Rabinowitz' statement that the framers created a gem when they put Article 4 together, and the perfect balance between merit and appropriate political input, I think, is brilliant. And I think it's given us a judiciary where you don't walk into a courtroom and say, now, how much did this one contribute to my campaign, and how much did this one contribute to my opponent's campaign? And, 3 years going to Conference of Chief Justices, I met a lot of Chief Justices from other states, and I never heard anyone say anything other than, you guys have a great system. And I think it's because of you, Vic, and your colleagues in 1955, and I think we all should be incredibly grateful for it, and I am.